Hello, sir. May I help you?
Good morning. I have an appointment at 10:30 with Susan Zeal.
There are two main reasons why people come to see a lawyer. Either they've got a problem and they need help, or else they're looking for help in order to prevent or avoid a problem. The funny thing is, so many times when I talk to the people who come to me with issues, it becomes very clear, very quickly, that if only they had come to see me sooner, their big issues could have become smaller issues, and their smaller issues would have never had to happen in the first place. Let me give you a for instance. Cindy was a healthy 50-year-old professional with a very successful career as an executive. Cindy was married and she had 2 adult children.
And she one day was coming home after presenting a presentation to a local bank. The presentation went extremely well. She thought that she needed to tell her boss that, communicate to her boss, to her husband. She wanted to let them know that it was going okay.
And instead of waiting until she got back to the office to call her boss about the meeting, she decided to use her cell phone.
So she was texting while she was driving, and unfortunately, as sometimes can happen when people text and drive, she wasn't paying attention.
And so she collided with a semi-truck and suffered serious injuries that left her ultimately in a vegetative state.
She was so young, I think as many people think when they're in their 30s, 40s, and 50s, that they don't really have to address what might happen if a major life-threatening event occurs in their life.
Cindy had never expressed her wishes with her family or her friends.
As far as if something like this happened, would she want life-sustaining procedures? Would she want artificial nutrition, etc.?
As a result of that lack of pre-planning, this left Cindy's family in a very difficult situation.
The medical providers didn't really know what her wishes were. Her family didn't know what her wishes were. And so they were left with trying to decide amongst themselves what they thought she would want.
Whether or not to continue or withdraw life support.
But of course that gets intermingled with their own personal beliefs. And so sometimes it doesn't always turn out, I don't believe, exactly how the patient necessarily would have wanted it.
To make matters worse, the family disagreed on what should be done.
The husband felt that she would not have wanted to continue to live in this manner. The daughter, Hannah, felt that her mom would have wanted to continue to fight no matter what the cost was and continue with all life-sustaining support. And the son, Matt, was in the middle between the two of them, and he didn't really know what to do. So there was great discord amongst the family members.
Many hours of time were spent discussing these issues, and the family experienced a great deal of strain.
The family was going through a great deal of grief and turmoil, and much of that could have been prevented had Cindy taken the time and spoken about it with her family, about what her wishes would have been in case something like this had happened, or even with her medical providers. But unfortunately, she did not do any of those things, and it left the family having to make this decision for her.
By doing a little bit of upfront soul searching, and certainly by speaking with someone like myself, Cindy could have identified and articulated some healthcare decisions in advance. Under Indiana law, there are tools available to express our healthcare decisions in advance and to make sure that they are legally protected, especially if we're in a situation where we're not able to express those wishes ourselves. The tools include the living will, the healthcare power of attorney, and the anatomical gift declaration. These tools are often called advance directives. Your advance directives protect your right to determine your own medical decision-making when you are unable to express your wishes. And they provide guidance to your loved ones and medical professionals in terms of what you want and do not want in terms of medical care. By becoming familiar with these tools, you can put them to work not only for yourself, but also for your loved ones.
It's like setting up a contract with your loved ones, with your medical providers, so they know exactly what your wishes would be if an event happened like this in your life. And oftentimes, attorneys or lawyers can help you go through the documents and then help you determine what you would want to have happen.
Although not required, the services of a good attorney can make things go much more smoothly.
The Indiana Living Will Act allows you to communicate with your doctor and family members about your wishes regarding end-of-life care if you have a terminal condition and you're unable to speak for yourself. You have a terminal condition when you have an illness or injury that you won't recover from and that will result in your death within a short period of time if life-prolonging procedures are not used. Life-prolonging procedures include things like CPR, a breathing machine or ventilator, or receiving nutrition and hydration through artificial means like an IV or feeding tubes. Indiana law recognizes two types of documents that can help you communicate your medical decisions to your doctor and family members if you have a terminal condition and you can't speak for yourself. One of those documents is called the Living Will Declaration, and the other is called the Life Prolonging Procedures Declaration. These documents aren't perfect, and they can't answer every question that might come up at the end of life, but they do provide good evidence to your doctor and family members about the kind of care that you would want. It also relieves a great deal of the stress and guilt that family members feel when they participate in these important decisions. A living will directs your doctor, family members, and loved ones not to provide or to withdraw certain kinds of medicines or life-prolonging treatments that only artificially prolong the dying process. Having a living will does not mean that you won't get good comfort care and pain relief, and it doesn't mean that you'll be denied aggressive care when you have a non-terminal condition. A life-prolonging procedures declaration directs your doctor, family members, and loved ones that you do want life-prolonging procedures performed when you have a terminal condition to extend your life. To make these documents effective, you have to be 18 and of sound mind. You have to sign the documents or have someone sign them for you in your presence, and you also need 2 adult witnesses. Finally, you need to communicate the fact that you have these documents to your physician. You can revoke a living will at any time. You don't need to call a lawyer, and you don't need to download a form off the internet. You can write a note saying that you revoke your living will, sign and date it. You can destroy the document or have someone destroy it in your presence, or you can verbally tell people that you have an intent to revoke your living will. Healthcare providers are not legally required to provide life-prolonging procedures that you've refused through a living will.
The Indiana Power of Attorney Act is the law in Indiana that allows someone to appoint another individual to make decisions for them if they're unable to make those decisions themselves, either because they are incapacitated, or which is most likely, or because they are away for some period of time. Those decisions could be financial decisions. They could also be healthcare decisions, which in our instance is what comes to mind most frequently. In order to establish a power of attorney, the principal, which is what we call the person who wants to create the power of attorney, needs to appoint an attorney in fact. The attorney in fact is what we call the person that is assigned the authority to make the decisions. Contrary to what someone might think, an attorney in fact does not actually have to be an attorney. It just needs to be an adult who is capable of making decisions. So someone who has the mental and physical capacity to meet the duties of the job can be appointed as an attorney in fact. The power of attorney itself needs to be in writing, and it needs to be signed by the principal in front of a notary public. After that's done, the power of attorney document is valid and can be exercised according to the terms of the document. What you'd want to do with that document in the case of healthcare decisions is to provide a copy to your primary physician when you execute it. That way your physician has that information if an emergency ever should arise. You can also provide a copy of the document to the person that you're appointing as your attorney in fact. If you do that, you need to make sure that the person you're appointing is someone that you trust, because once they have the attorney in fact, it can be difficult to revoke it. Indiana law is very broad when it comes to the powers that can be granted under a power of attorney document. So it really depends on what the principal wants to assign to the attorney in fact, and it can be basically whatever that person wants. There are 2 classes of responsibilities that can be granted to the attorney in fact. One class would be financial decisions, and the other would be healthcare decisions. Financial decisions can be anything from actually paying your bills to making transactions with your property, selling your house, entering into contracts, executing contracts that you entered into before your incapacitation. Healthcare decisions can be anything from simply saying yes or no to certain care, to withholding care, to making choices between different types of care, and also making admission or release decisions from facilities such as hospitals or long-term care facilities. So in our instance, one of our primary concerns is that we have healthcare decisions that need to be made for the patient. And the healthcare power of attorney document would grant to the attorney-in-fact the authority to make decisions and consent to care. So the doctors would be able to actually treat the patient in the hospital immediately. I think that when someone drafts a power of attorney, they do need to put some thought into the whole process because it's a very important document. And the power of attorney is you granting all of the power you have to make decisions for yourself to another person. So some things that you want to consider really are, do you trust the person that you're going to be appointing as the attorney-in-fact? Do you trust that they would make decisions that you would make for yourself? And most importantly, are you comfortable discussing those decisions with them so they actually know what your wishes are when the time comes? This is not a time making these decisions when you want to strictly be fair. I know a lot of my clients who are elderly, they have 2 or 3 children, and they have a situation where they feel like they always have to treat their children alike, and that's what we all want to do with our children. But it's entirely possible that some 1 or 2 of your children might be better at making these decisions or in a better position to do that than others. When you're drafting your power of attorney, it's important that you state specifically who you want making your decisions without regard to what someone's feelings might be after the fact, because your effort to treat everyone equally may really thwart your desires in the end if your children, for example, don't get along very well, or if they're not very good at communicating among themselves. So this is a time really when you, as the principal, need to really do a lot of soul searching and figure out what you think is best for yourself, who's going to make the best decisions for you. But you also need to go on and have that conversation with your family and your friends as well. And it really can be an opportunity to maybe smooth things over preemptively rather than let this spring up when you're not able to speak for yourself.
The Uniform Anatomical Gift Act really spells out what you need to do and what you need to know what to do if you want to make what's called an anatomical gift, or really in so many words, donate your organs to someone else, either during life or upon death. The law itself defines an anatomical gift as either all or part of your body that would be donated or made a gift for purposes of transplantation, medical, scientific, or other research purposes. And if you'd like to do this, there's a number of steps you should be aware of. There's a number of ways to make clear your intention as to whether you would like to make an anatomical gift or donate your organs. And also, if you would not like to do this, again, there's a number of ways you can make that clear as well. One of the most common methods used to state your intention as to whether you want to make an organ donation or, again, this anatomical gift is to make the proper indication on your driver's license. You can also carry what's called an organ donor's card, which needs to be signed by the donor, which indicates your intent to make this anatomical gift or be an organ donor. And finally, you can make it clear in a legal document such as your will that you would, upon death, want your organs donated for certain purposes. Generally speaking, to make an anatomical gift during life, you have to be either an adult or eligible under Indiana law to receive a driver's license. Individuals who want to make an anatomical gift or donate their organs that are under the age of 18 will need their parents' consent to do so. If you've made your intentions clear that you would like to make an anatomical gift or donate your organs, other members of your families can't prevent that gift from being made. If you're silent or during your life you have not made any indication as to whether you would like to make an anatomical gift or donate your organs, then your family can choose upon your death whether to make an anatomical gift on your behalf or donate your organs. You can also make statements or make it clear that you don't want to donate your organs in any of the ways that we've mentioned, including you can indicate in your will that you would not like to make an anatomical gift or you refuse to do so, or through a written statement to others as well. Finally, once you've made an indication or made a statement as to whether you would like to make an anatomical gift and donate your organs or whether you would not like to do so, at any time during your life you can amend that statement or you can revoke that statement. If you haven't taken the formal steps to make your intentions clear as to whether you would like to make an anatomical gift or donate your organs, be sure to make it clear to your family what your intentions are so that they can be properly carried out. And in closing, if you want to make your intentions clear whether you would like to be an organ donor and make an anatomical gift, or if you would not like to make the anatomical gift or be an organ donor, be sure to make that intent clear either in a legal document such as your will, to carry an organ donor card, or to make that indication on your driver's license.
Of course, when you sit down with your attorney to discuss these matters, you'll go into greater detail. The attorney will provide you with more information about the tools. They'll ask you more questions about your wishes as they would relate to future healthcare decisions. And certainly the documents would be completed such to protect those interests in the future.
Planning ahead makes a lot of sense, so you have to wonder why more people don't do it and why people are so reluctant to do it.
I think it's because people feel uncomfortable about the possibility that this type of situation could happen to them and they may have to depend on others to make these decisions for them. This is especially true for young and healthy individuals. People just think, this will never happen to me.
The worst thing that you can do is to do nothing at all, the consequences of which could be devastating. And that's not to have any healthcare wishes in writing to help those around you make those decisions for you when you're not able to do it yourself.
Expressing your wishes about end-of-life care doesn't have to be a big deal. It doesn't have to be anything elaborate. The most important thing to do is talk to your family members and your loved ones. Tell them that you've thought about this and the kind of care that you want at the end of life. Make sure you talk to your physician, and the physician can enter a note about your discussion in the medical records.
Certainly there are legal and practical advantages to having a written declaration that specifies your wishes and also identifies the persons that you want to make these decisions on your behalf at a later time. So even though it might feel uncomfortable, please give consideration to formally making your advance directives known today. Be sure to inform those individuals that you are naming in your advance directives that they have been appointed, and be sure to discuss your wishes with them. With a little planning, your advance directives will provide the voice for your wishes about health care when you're unable to speak for yourself.